will have a stipulation with council, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So what evidence do you have that she will continue to have future? I guess she testified that it still bothers her, is that?
Yes, yeah.
Okay. Any objection to 3932?
Yes, Your Honor, I'm not sure that she testified that it still bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct. And this is just not an appropriate, this is not an appropriate instruction in a case like this where it's over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by the
You want to respond to that?
Go ahead.
So I'm pretty confident that if it was changed to 40 years, it would fall well below the threshold of the National Vital Statistics Report. So I'm willing to do that. If there's a different number that they propose, I'm fine, but there should be some kind of KC 3932 of life expectancy so that the jury can understand that.
Where's that chart in the cases? Oh, here it is.
It's
And she's 32 today?
yes, she's 32 years old. Yes, she is.
It appears to be correct. This is 50.3 and they've got 50. All right, I'll give 3932 over plaintiff or defendant's objection.
Thank you.
All right, plaintiff proposed 3901. I think I already gave 3901. Is that not correct? No, I gave 3900. I did. Oh.
Your Honor,
Yeah. So 3901 is only if liability has been established, not contested.
I apologize, that's an error.
Okay, so that's withdrawn?
Withdrawn.
Okay. 3902 already gave. 3903. I did not give, but I think that was proposed by the defense.
that's correct, Your Honor.
And that's the defense version was straight from the casing.
Yes,
Now,
it's in the binder.
the one that I did, Your Honor, is from the KC, which seems to have a lot more words than theirs.
Yeah, I already did give 3903.
So we're gonna go with their version then?
It's straight from the casing. 3905, I think I already gave.
May I be heard on that, Your Honor?
Go ahead.
So the one that I've submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount. It's missing an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read to the
Right. I just looked. I did not give 3905 on Wednesday. And plaintiff's is straight from the casing.
Yes, sir.
And defendant had a different one.
I think theirs is 3905A, so maybe that's why. But I would like 3905.
Your Honor, I believe the difference is that 3905 and 3905A, we just submitted them as separate instructions, and plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define,
Doesn't cover.
yeah, it's not the full instruction, so I'll give plaintiff's proposed instruction.
Thank you.
All right, 1600. I think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s, but I may be mistaken.
Your Honor, it was the 1602 instruction, which was the special instruction 4 we discussed earlier.
I did give 1600 already.
I withdraw the objection as to the 1600s.
Okay. Did we give a version of that?
1602 is the special instruction 4 that we discussed a few minutes ago.
And that would, okay,
And
so I'll give the modified version.
thank you.
1603, did we give that?
1603 was included in ours as well. I believe the court asked that we include it, so
Okay.
that's in our binder.
And 1604,
I believe was given.
was already given. All right, and tell me we have an agreed upon verdict form.
Unfortunately, we do not, Your Honor.
Can you highlight the differences?
Well, yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language. It's also something that was just created as a form that doesn't really reflect any type of special verdict that's really I've seen in any case before. I'm not sure what that is. So the one that I've done, Your Honor, I've done two different ones. The distinctions of two that I've submitted is page 7 is added with respect to punitive damages. And the other version does not have the punitive damages. Question number 19. That is the only distinction between the two versions that I've filed with the court. And I did give a courtesy copy to counsel. It was filed today at 12:19 a.m. with two different verdict forms. I did submit it to the court this morning without the caption of the attorneys, just so it would be somewhat of a neutral form. And I request that one of these be used because the one that we've provided doesn't really follow the usual method. I don't think it even has a signature line. Let's see. No, I withdraw that, but it doesn't really cover it the way that's usually done from what I've seen. Thank you.
All right, so I noticed the plaintiff's version has damages for each cause of action, which is duplicative multiple times over. It also doesn't include self-defense, and it also doesn't include what was the other affirmative defense?
Contributory negligence.
Oh, comparative.
Yeah.
Contributing away on some of them.
Yeah. Thanks.
All right.
I can modify it.
Your Honor, if I may.
Yes.
What we submitted was to simplify the form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion that the previous form was complicated, which we agreed. We believe this is clear cut. It includes all the issues. It should not be difficult for the jury to understand or to answer.
Can I respond there?
Go ahead.
So the worst part of it is it again states by a preponderance of the evidence. That's not usually in a special verdict form. They put that throughout the questions, kind of limiting, kind of creating a way for the jury to think ahead of time. It just doesn't make sense to have that there. I can modify mine. I have a printer. I can make changes in a couple of minutes and print out the version the court wants me to print. The special verdict that I've submitted, I've seen all kinds of attorneys use it. I've never seen this version. And they would have to change it anyway because of the preponderance of the evidence, and it doesn't really tell the jury how to move along. So for example, under assault, you have a question, yes or no, and then it says if you answer question 1 is yes, then answer question 2. If you answer no, then proceed to question 6. Theirs doesn't have any of that. It's very confusing and has that preponderance of the evidence language. So definitely I would ask that that language be taken out, preponderance of the evidence. And if we could follow more along the lines of a special verdict form, that would possibly make it a better form, but it's still a little confusing.
Your Honor, as far as the instructions, it's just clearly not true. The verdict form specifically states what the jury is supposed to do after they answer every question. There are other problems with plaintiff's form that would be beyond just little modifications. As you mentioned, the damages issue is very likely to lead to confusion and possibly duplicative damages awards. So if the court is inclined to ask that one of these be modified, we believe it should be this one. And we would, if the court has an issue with the preponderance of evidence language, we can strike that language. Otherwise, it would be the same.
Can you strike it and print it within
Yes.
the next 5 minutes?
Certainly in the next 10 minutes.
Be heard.
Go ahead.
So again, Your Honor, the way that they've had it is not the way that the Casey instructions read. The Casey instructions do not have these boxes. It's a confusing way. It doesn't allow the jury to really answer the questions. They have to just say yes or no for everything. It doesn't break it down. So for example, they're not able to answer the 4 parts of the question. For example, assault, it has 4 parts. And their form does not have the ability, the jury cannot answer the 4 different parts. They have to either go with everything or nothing. And that's not how a special verdict form or any verdict form is done. So I have a printer with me today. I can make changes. I can email it to the court if the court wants to do something with it. Their form doesn't cover any of these questions for any of them. Either it's all or nothing, and that's not how a special verdict form reads. So I would ask that the court allow.
I'm just inclined to do a general verdict at this point in time.
I'm willing to accept that, if that's what the court wishes to do, but theirs is really off base, and it does not cover all the 4 parts.
Your Honor, there's multiple causes of action. Affirmative defenses that apply to some causes of action, but not others. We believe it's important, at least for our appeal rights, among other things, that we have a special verdict form in this case. I'd be happy to work on it.
Well, I mean, actually, I think the defendant's proposed verdict form is the equivalent of a general verdict.
Well, may I read yours, please?
Go ahead.
So again, I'm looking at my form here, and first of all, the question is, are we doing the punitive damages question? If I can narrow it down to, does the court want number 19 or not?
Well, I'm not inclined to do the plaintiff's version at this point in time.
No, I understand, but I just wanted to know if you wanted to have punitive damages, if that question, because the question is the same.
Your Honor, under the motion to bifurcate, the jury decides entitlement to punitive damages.
Exactly. So here's my question on punitive damages in the defense's proposed version. You've got punitive damages attached to negligence. Was that your intention?
Along with the instruction that it cannot be caused, that punitive damages are not awardable if the conduct was by mistake.
I'm sorry, you said you can get punitive damages for negligence?
No, not if it's by mistake.
Not if it's what?
No, we don't believe you can.
Okay, so, but you do have a punitive damages question linked to question number 9, which is damages for negligence and comparative.
We can strike out the end of that of 12.
Okay.
Question 12.
Here's what I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action. I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section, whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So we did it. We did the form this way just to avoid having to ask questions like, did you answer question this? Did you answer question that? However, if you look at question 7, for example, it says if you already answered question 4, which is the same, skip this question. So the intent is to have only one of those be answered. And if you fill the form out, that's how it works.
May I respond?
Go ahead.
Each cause of action can have its own separate damages. And that's why in their form it is the way that they have it, and that's why I did the same thing. So I would request that the jury be allowed to break it down on damages and decide what type of damages are for assault and battery. Those are kind of coupled together. It shouldn't be, but they are. And then intentional infliction of emotional distress.
And that arguably kind of makes sense to me. Let's say that they find that the assault was limited to the scratch and nothing more. That the scratch itself did not cause past or future, maybe isn't going to cause future emotional distress, but they find that the intentional infliction of emotional distress was more longer lasting.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery and no intentional infliction of emotional distress. By removing the damages section, they would never be able to award any damages. So that's why I request that it at least be left there so that they could give damages to the parts that they wish to give. And counsel on both sides can argue duplication, don't give it twice, break it down.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages awarded.
Your Honor, they have multiple attorneys on their end. They've created this form. If the court is going to go along with their form, then they should have to live with the form that they created.
The form that we've created does not have that risk of duplicative damages. The I'm sorry. The other thing is that I think we've already established with the jury instructions that there are not damages that are awardable under some causes of action that are others.
Can I add one more thing, Your Honor?
Go ahead.
Yeah, I'm sure the court has seen it in many cases where it is broken down. There's the damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional distress. In closing argument, counsel obviously can argue how this form should be filled out, and as confusing it is to me, I'll have to just live with it. To take away the damages section in assault and battery would mean that it's too confusing. It should be separate so that the jury can decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Your Honor, we could, in theory, have one question for the damages and just not duplicate them. And that the only difference there would be we would have questions like, did you answer yes to question 3? Did you answer yes? Like what we did with the punitive damages. That would be one more difference.
How about we modify question 7? What are Ms. Ellis's damages? If you answer question 4, only include additional damages for this cause of action.
Can we include if any, Your Honor?
If any.
So again, it is very confusing because assault and battery is a separate cause of action and has its own damages component. By leaving the form as is, the jury can then decide if they're going to give any damages for assault and battery.
They can, it's under question 4.
Right, in 4. And then they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
But you can't double count.
I'm sorry, Aaron?
You can't double count though.
Double count, what does that mean then?
Meaning include the same emotional distress that if they find that she has a certain amount of emotional distress, are you asking them to?
PDF Filler makes it possible to sign any PDF online in just a few clicks. Open or upload the document you need to sign, click the Sign button to open the signature wizard. If you have used PDF Filler to sign documents before, you'll have your PDF signature saved. If not, add a new one by typing, drawing, or uploading it. Move your signature around the document to place it in the right spot. Click Done to electronically sign your PDF.
To make things less complicated.
Go ahead.
So yeah, separate verdict form complicates it even further. This is a form that defense has prepared. It was well thought out, and it doesn't even break down the 4 different parts of the question. If we're going to live with this, I ask that at least we have those damages for each section I'm not gonna ask for the same thing 3 times. It's gonna be broke. If I'm gonna do it, I would break it down. This is worth this, the other is worth the other. It's not the same, Your Honor. So I asked that the form resubmit it as is. And just, if the court is gonna go along with their form, then at least I would ask that. Thank you.
All right, I'm gonna ask that you modify question number 7 to, if you answered question 4, only include additional damages under this cause of action, if any.
All right, that makes sense. Thank you. And what happens with the other one, Your Honor, number 9? Same thing?
Same thing. Can we do that?
Yes, Your Honor, thank you.
All right.
And Your Honor, will we be giving number 13?
Yes.
Your Honor, just to confirm, question 12, we're going to omit the last 3 words or question 9.
Correct.
Thank you.
All right. There's a request for judicial notice regarding the date of the NBA game.
Yes, there is. I did file that yesterday, and I served it a copy on defense counsel.
And I'm sorry, what was the testimony of the date that the photograph was taken?
Miss ALMANZAR stated that that the photo was taken on the date of the NBA All-Star game, which was the date of the accident, the date of the incident of February 24, 2018, about 6:30 p.m. She testified that that's when the photograph was taken, and her nails looked like that on that date. There's no question that the All-Star game was on February 18th of 2018, so it's just a clarification so that the jury is clear of when the game is. This is common knowledge. There's no question about it. I've given different exhibits confirming that the All-Star game was on February 18th of 2018, and that's why I filed this.
All right. And for the defense?
Yes, Your Honor. What Mr. Rosen is saying is absolutely false. I'd like to read what my client testified to. CARDI, I'm going to put this in front of you. CARDI, can you please look at this photograph and tell me, do you recognize this? Answer, yes. Question, what's this photograph? Answer, that is me out here in LA at the All-Star Weekend NBA game. Question, does this picture refresh your recollection about what your hair color was that week? Answer, yes. What color was it? Answer, I'll say
Read
like...
more slowly, please.
Sure. Answer, I'll say like an ashy, dirty blonde. Question, can you see your nails in that photo? Answer, yes. Question, were you wearing acrylic nails or some other type? Answer, acrylic. Question, I think you testified yesterday that acrylic nails can last you up to 2 weeks, is that right? Answer, yes. Question, are those the nails you had the entire time you were in LA? Answer, yes. And I can continue reading, Your Honor, but nowhere does my client say that this was taken on February 24, 2018. She doesn't reference a date. And Mr. Rosen represented this to you twice last Wednesday, that the court was advised and everybody was advised that it was on February 24th of 2018. He later said she testified that she got this picture taken on the same day. She testified under oath that at 6 p.m., he just said 6:30, on February 24th, 2018, that this picture was taken. That's absolutely false, Your Honor. I'd be happy to provide a copy of the transcript to the court.
Okay.
May I respond?
And one other thing, Your Honor,
Go ahead.
my understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I could refer the court to.
Well, I'm not necessarily worried about that. I'm just worried about whether, I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
May I respond?
Go ahead.
The purpose of this is really not to make anybody right or wrong. The purpose of judicial notice is just to clarify when the All-Star game took place. And the second half of it is when the photograph was taken. There's overwhelming evidence attached from different different news outlets. There's,
Again, is it material, the date? She said she had those nails for the entire week.
it's material, Your Honor, because the defendant testified that that's what she was wearing later in the day, exact same day. She had those nails. You have testimony all over the place about the fact that this photograph was taken on the same date of the All-Star game and the same date of the incident. What was the error there is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself that the All-Star game was on February 18th of 2018.
Okay, I'm gonna deny the representation of this. All right, are we otherwise ready?
There's one more thing, Your Honor.
Go ahead.
The court asked that I prepare a statement regarding the death of John Scherer.
Okay. Do you have that?
Yes, I do. I did give it to the court. It would say plaintiff testified that she treated with John Scherer, MD, in relation to this case in 2018. It is undisputed that Dr. Scherer died on March 5th, 2020.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court could instruct the jury that it is undisputed that Dr. Scherer died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify to that. She said she understood he died sometime in 2021. She also testified, and we launched the transcripts, I can cite to where in the transcript she says it, page 148, lines 12 through 149, line 15, she says that she went to see a Dr. Scherer and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Scherer is not supported by the evidence. It is the March 5, 2021 date is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Scherer died, period.
Okay.
You heard?
So, this is what I would propose reading. Plaintiff testified that she treated with John Scherer, MD, does not dispute that Dr. Scherer has passed away.
Your Honor, she did not testify she treated with Dr. Scherer. She sought medical treatment. This is page 148, line 12 through 14. Around that time, unclear when that is, did you also seek medical treatment from Dr. John Scherer? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So,
Okay.
that goes on page 149.
So I will read, plaintiff sought treatment with John Scherer. It does not dispute that he's passed away.
Well, plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will we read, Your Honor?
Plaintiff testified that she sought treatment with John Scherer, MD. It does not dispute that he has passed away.
Thank you, Your Honor.
Okay. Now are you ready?
Well, there's a couple things. In my closing argument, I need the verdict form. So I can't start
Understood.
without
We're working on that.
that in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in my closing.
It's not in evidence. I think what you said was they didn't provide the date. And you're fine, you can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing,
You could argue it. You could argue that they didn't establish what the date was.
and also that the All-Star game was on February 18, 2018, the week before. But the week before the incident, I don't see the harm in that. They can object to that. They can say their version. That's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in
Okay.
discovery.
Go ahead.
just briefly, a couple of questions. First, if you remember, counsel violated a motion to eliminate order. And now he's talking about arguing things that are not valid.
Do you suffer from FOMO? Fear of missing out on your favorite sporting event when you're away from home? With IPVanish VPN, you don't have to worry about streaming content over unsafe or restricted Wi-Fi to watch your favorite events. IPVanish VPN allows you unlimited and secure streams to all your favorite sporting events. Don't let unsafe Wi-Fi and ISP throttling stop you from cheering on your home team or favorite athletes. Get IPVanish VPN now.
Really see it.
I don't think so. We're in the middle of a transition, and I don't know.
Okay. And
We can see it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show or intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right. Anything else from plaintiff's counsel?
Yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date, and you can make that argument.
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right. Are we ready to move to the jury?
I must have the verdict form before I start.
All right.
They're being printed right now.
Okay. All right. Let's move in. All right, welcome back, everyone. We're still on the record in the Ellis matter. We now have defendant with us as well as the members of our jury and our alternate. Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend. Folks, we thank you for your patience. We did have a few procedural issues that we needed to address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent and that Ms. Ellis's negligence was a substantial factor in causing Miss Ellis's harm. If Miss Almanzar proves the above, Miss Ellis's damages are reduced by your determination of the percentage of Miss Ellis's responsibility. I will calculate the actual reduction. Miss Ellis may only establish her claim for negligence if she proves that Miss Almanzar engaged in negligent conduct that caused Miss Ellis to suffer physical injuries. If Miss Ellis can prove that Miss Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Miss Ellis cannot establish her claim for negligence. Emotional distress includes suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Miss Ellis claims that Miss Almanzar assaulted her. To establish this claim, Miss Ellis must prove all of the following: that Miss Almanzar acted with the intent to cause harmful or offensive contact, that Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Miss Ellis did not consent to the conduct, that Miss Ellis was harmed, and that Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to mental distress. Under Factor A, which is the position of authority, examples of positions of authority or relationships of power include an employer to his employee, an insurer to its insured, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar knew that emotional distress would probably result from her conduct, or Ms. Almanzar gave little or no thought to the probable effects of her conduct. If you decide that EMANI Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another 50 years. This is the average life expectancy. Some people live longer, others die sooner. The published information is evidence of how long a person is likely to live, but is not conclusive. In deciding a person's life expectancy, you should also consider, among other factors, that person's health, habits, activities, lifestyle, and occupation. Ms. Ellis seeks damages from Ms. Almanzar under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by EMANI Ellis: physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, EMANI Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate EMANI ELLIS for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar engaged in that conduct with malice, oppression, or fraud. If you define that defendant accidentally harmed plaintiff, punitive damages are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether the defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction, and we're back on the record with the court reporter. That concludes the additional jury instructions that we are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who
At Insurify, we make it easy to cut your car insurance bill in half. Half? How? Just go to Insurify.com and compare dozens of quotes in a few clicks. You cut out the middleman so you can cut your bill in half.
I just saved like $1,000.
Save up to $1,000 a year on your car insurance.
We had a brief conversation at sidebar, and now is plaintiff prepared to proceed with your closing argument as soon as you get there?
Yes, Your Honor. Thank you very much.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Thank you all for coming back today. So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%, maybe a featherweight more than 50%. 51%. It's not 100%. The standard is a little bit more than 50%.
In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar or the cut came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails, and that there were three different scrapes, three different scratches, and that the middle one was the deepest one, and that's really the one that he worked on. Now, the issue in this case is, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss Almanzar, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay? If you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are, EMANI Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss EMANI Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. They were all ignored. Instead, the defendant thought that, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person. And she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on the call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher, a sentence that basically that it's undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some.
We ran a promotion cutting the price of Mint Unlimited in half. And it was so popular, we're doing it again. It's like a sequel that's actually as good as the original. Maybe better. Definitely not worse. Okay, it's exactly the same.
Slow down, honey. Too fast, Trevor, too fast.
I know what I'm doing, Mom.
Ah, a new driver.
Yeah, I'm a little freaked out.
If there's one thing to freak out about, it's higher insurance rates.
Yeah, but who has time to deal with that?
Not you, clearly. But the Zebra does. We compare over 100 insurance companies to find savings no one else can, up to $400 a year.
Trevor!
Oh, look, it's my stop. The Zebra. We do the searching, you do the saving.
To that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those two witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath. They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those four things happening, being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry, she was emotional. So when these two witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that. And they had assumed that it's her fault, maybe, or that she did something wrong. But again, those two witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the two people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything. At some point during the trial, the defendant showed you Exhibit 232. If you all remember this photograph, Exhibit 232, this is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection.
There is no proof of when this photograph was taken. It could have been taken at any time, before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere. That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph. The next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Ms. Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs at the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, and she met with him there, Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case, but he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law is. So where is Mr. Newton? I don't know. He was on the witness list. He should have came here and testified. Another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw a Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple of reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. I'm sorry, if the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. The medical treatment was delayed. That's why Ms. Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lean basis. Dr. Mulliken testified that he would agree to that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Miss Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Miss Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Miss Ellis could, there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind. Now,
Frankie's been eating Farmer's Dog for pretty much her whole life, and she's been super healthy. She's the best. She's fun, loving, super high energy. She's a good big sister to her 2 little sisters. Like, just Stella?
Yes, baby. Good job.
We've made some special freezer space for Frankie's food because she loves it. It's super important to us.
What happens when you combine the best e-signature solution with the best document management solution? You get a seamless integration with Sign Now and PDF Filler. Now, when users initiate signature requests in the PDF Filler mobile app, these requests can be sent via the Sign Now app on any mobile device. If Sign Now isn't installed yet, users will be automatically redirected to the App Store where they can easily download it. With Sign Now and PDF Filler, the integration is seamless and the time you save is limitless.
when you go back into the jury room, you'll see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
Objection, Your Honor.
They were raised.
Sustained.
When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was the security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen. And that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony. When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there. At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified. She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident, and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was the hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser she didn't tell him about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case to, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything had already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B, and Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Miss Ellis also received another 12 visits of, she testified that she saw a psychologist, Dr. Avila, and other people in his office.
Violation of the court's order.
Move on. The other thing that Cardi B failed to do or could have done is she could have filed a cross complaint.
Objection, Your Honor.
All right. And then I want to go over a little bit about the medical bills. So you don't have to get it exact, doesn't have to be an exact number. But there was testimony in this case that Ms. Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.